When the government starts telling you that safety outweighs freedom, history shows which one disappears first. And that's exactly what's happening right now in New York, where Governor Kathy Hochul has just signed into law a new mandatory firearm confiscation policy that could reshape how the Second Amendment is interpreted for millions of Americans. This isn't just another tweak to the state's red flag laws. It's a direct order that removes police discretion entirely. Under this new law, whenever officers respond to a domestic violence or family disturbance call, they are required to seize firearms from anyone involved if a victim expresses fear or if an officer believes a weapon must be removed to prevent harm. There's no warrant, no hearing, no due process before the property is taken, just immediate confiscation. Supporters say it's about protecting victims, but the reality is far more complex and dangerous, because this mandate doesn't just stretch the limits of public safety policy, it tears at the very fabric of the Fourth, 14th, and Second Amendments of the United States Constitution. It shifts power from the courts to the responding officer, turning a split-second judgment call into a legal deprivation of rights. Now, to understand what this means for gun owners, not just in New York, but across the nation, we need to look deeper. Why did this happen now? How does this law compare to past Supreme Court rulings like New York State Rifle and Pistol Association versus Bruin, 2022? And most importantly, could this become the blueprint for nationwide gun seizure mandates? Because make no mistake, when one state decides that fear is enough to justify confiscation, every law-abiding citizen has something to lose. When people hear about a new gun law in New York, they often assume it's another round of restrictions, but this one goes further than most realize. Under Assembly Bill A544-B and Senate Bill S1985-B, officially signed into law by Governor Kathy Hochul in October 2025, the state has redefined how police respond to domestic and family violence calls. The change might seem procedural, but its implications reach deep into constitutional territory. The law amends Criminal Procedure Law, Section 140.10, and here's the key phrase: officers shall take temporary custody of any firearm when they respond to a qualifying domestic or family incident. That single word, shall, means this is no longer about officer judgment or context. Discretion is gone. If a victim expresses fear, or if an officer believes removing the weapon prevents harm, the firearm must be seized on the spot. The statute sets a minimum holding period of 120 hours, 5 days, before the firearm can be returned, and crucially, no maximum limit is defined. That gap leaves gun owners in legal limbo, waiting on bureaucracy to determine when or if their property will be released. Supporters call it a cooling-off period. Critics call it an open invitation for delay. And the scope is wide. The law applies to firearms, rifles, and shotguns, and through cross-reference state definitions may also cover stun guns, electric dart devices, and even imitation or disguised weapons. This means that even antique or non-lethal devices could fall under the seizure mandate, depending on interpretation. Advocates in Albany say the goal is to prevent domestic tragedies by ensuring immediate disarmament during moments of crisis. Yet, according to New York State data from 2018 to 2022, about one-third, 34%, of domestic homicides involved firearms, while the majority involved knives or blunt instruments. The data doesn't justify the breadth of the measure, and that's where the concern lies. Because when a law removes discretion, extends seizure timelines, and broadens what counts as a weapon, it ceases to be about safety. It becomes about control, and that's a line no free society should cross lightly. Every time a government claims it's protecting you, it's worth asking, at what cost? That question cuts to the heart of New York's 2025 firearm seizure law, signed by Governor Kathy Hochul under A544-B/S1985-B. It's sold as a safety measure, but the Constitution doesn't bend just because the state says, "Trust us." Under the newly amended Criminal Procedure Law, Section 140.10, police officers must take temporary custody of firearms when they have probable cause to believe a family offense occurred and when removing those firearms is reasonably necessary to prevent harm. Supporters call that common sense. But let's be honest. Whenever the government decides when and how citizens can keep their arms, liberty becomes conditional. And conditional liberty isn't liberty at all. Yes, this law technically requires a basis stronger than fear. It needs reasonable belief grounded in probable cause. But anyone who's worked around law enforcement knows that probable cause is one of the most elastic phrases in the legal dictionary. It's wide enough to fit honest mistakes, political agendas, or simple bias. That's why the Fourth Amendment exists, to make sure no property, especially a firearm, is seized without clear, judicially reviewed evidence. Here, that oversight comes after the fact, not before. By the time a judge sees the case, the right has already been interrupted. The 14th Amendment guarantees due process, but waiting 5 days or more for your property to be returned is due process in name only. Rights delayed are rights denied. Sure, you can file a challenge, but only after the damage is done, your firearms taken, and your reputation questioned. Then there's the Second Amendment, which doesn't ask for permission slips or emotional exceptions. Even after Bruin, 2022, reaffirmed the individual right to bear arms, New York is again testing that boundary. And while Rahimi, 2024, allowed temporary disarmament in domestic violence cases, it did so under clear judicial restraint, not open-ended administrative power.
The state's job is to punish crime, not preempt it by assuming guilt. Mandating seizures based on an officer's judgment without real-time judicial oversight edges dangerously close to government overreach. The Constitution wasn't written to make us comfortable. It was written to keep the government in check. And when comfort replaces principle, freedom is already halfway gone. The problem with giving government power isn't what it does today, it's what it can do tomorrow. And that's exactly why New York's mandatory firearm seizure law deserves scrutiny from every law-abiding citizen who still believes in due process. On paper, this law sounds controlled. It says police can only seize weapons when there's probable cause of a family offense and reasonable belief that removing firearms could prevent harm. But in the real world, anyone who has ever responded to a domestic call knows that these situations are messy, emotional, and often unclear. Allegations fly, tempers rise, facts blur. Yet now an officer's quickest path to compliance isn't investigation, it's confiscation. This is where mandatory enforcement becomes dangerous. When discretion disappears, so does judgment. Officers who fear administrative punishment or media backlash are incentivized to err on the side of seizure because keeping your guns might cost them their career, while taking them costs them nothing. That's not law enforcement, that's risk management at the expense of liberty. And for the citizen on the receiving end, the fallout is immediate and punishing. Even if no charges are filed, the clock starts ticking on paperwork, storage fees, and legal costs. You might spend hundreds or thousands of dollars just to reclaim property that was never used in a crime. The law says you can request your guns back after 5 days, but anyone familiar with bureaucracy knows that 5 days can easily stretch into weeks. The danger doesn't stop there. Once a law like this exists, it becomes a template. Other states watch, take notes, and eventually adopt the same mandatory logic under different names. That's how overreach spreads, not through one sweeping federal act, but through 50 smaller steps that all point in the same direction. The lesson here is simple. Every time we trade discretion for mandate, and every time we allow rights to be paused for convenience, we teach the government it can do the same again. And it always will. Because power doesn't give itself limits, citizens do. To be fair, not everyone sees this law as an overreach. Supporters argue that domestic violence incidents involving firearms often turn deadly, and that even one life saved justifies temporary restrictions. They point to statistics showing that victims are 5 times more likely to be killed when an abuser has access to a gun. From that perspective, the 1,200-hour custody rule isn't tyranny, it's prevention.
Groups like the New York State Coalition Against Domestic Violence have applauded the change, saying that removing firearms during volatile moments gives victims a window of safety. They frame the law as a cooling-off period, a way to stop emotional disputes from escalating into irreversible tragedy. Even the Rahimi 2024 decision is cited by proponents who claim it validates temporary disarmament as part of modern risk prevention. They also argue that this isn't a gun grab because weapons are meant to be returned after 5 days if no charges are filed. In their view, the state isn't dismantling rights, it's momentarily pausing them to protect life. It's a compelling argument, and one that plays on empathy and caution. But as we've learned throughout American history, every infringement begins as an exception, and exceptions have a habit of becoming the rule. The supporters may call it common sense. Defenders of liberty recognize it as the slow normalization of control. Good intentions don't excuse bad precedent. And when a government starts deciding which rights can be paused, it stops being a protector and starts being a gatekeeper. The Second Amendment doesn't read, "shall not be infringed unless someone is upset." The Fourth doesn't say, "secure from searches except when the state is nervous." And the 14th doesn't allow property seizure without due process because fear was expressed. These principles aren't conditional, they're absolute by design, because our founders understood that temporary power always becomes permanent if unchecked. Once the government learns it can seize property in the name of safety, it will find new definitions of what safety means. We saw this with red flag laws, then magazine bans, and now mandatory confiscation during domestic calls. The slope isn't theoretical, it's already here.
Proponents claim these measures are temporary, but anyone who's navigated a bureaucracy knows that what's temporary for the state often lasts far longer for the citizen. And what's labeled reasonable today can be deemed necessary tomorrow. That's why these constitutional protections exist, to prevent emotional governance from overriding enduring law. The government doesn't get to suspend liberty because it fears what might happen. It must act within the bounds of what's proven, not what's possible. Because if freedom becomes negotiable, it's no longer freedom at all. It's permission, and permission can be revoked at will. At first glance, New York's 2025 firearm custody law looks like a narrow response to a specific problem, but dig deeper and it reveals a dangerous truth. The more we allow the government to define safety, the less liberty we have left to defend ourselves. This isn't about denying the reality of domestic violence. It's about insisting that even the most emotional issues must still be governed by principle. The Constitution doesn't vanish because the headlines are frightening.
The right to keep and bear arms, the right to due process, the right to be secure in one's home, these are not outdated ideals. They are the safeguards that keep emotion from becoming law and power from becoming tyranny. Across America, states are watching what New York just did. And if history is any guide, policies like this rarely stop at the state line. What begins as a temporary safety measure in Albany can become the model for nationwide enforcement. Each new restriction is sold as reasonable, but when stacked together, they build a system that treats freedom as a privilege granted by the state rather than a birthright guaranteed by the Constitution. The choice we face isn't between compassion and the Second Amendment. It's between trusting citizens to be responsible or trusting the government to decide who deserves rights. Only one of those paths preserves a free republic. So stay informed, stay engaged, and remember, freedom doesn't defend itself. Every right you fail to protect today becomes a regulation you'll end up fighting taxes for.